Good day everyone, my name is Rail Balimbingan. I am the first reporter from the Chapter 9 entitled Void or Inexistent Contracts. Article 1409, the following contracts are inexistent and void from the beginning. Number 1, those whose cause, object or purpose in contrary to law, morals, good customs, public order, or public policy. 2, those which are absolutely simulated or fictitious. 3, those whose cause or object did not exist at the time of the transaction. 4, those whose object is outside the commerce of men. 5, those which contemplate an impossible service. 6, those where the intention of the parties relative to the principal object of the contract cannot be ascertained. 7, those expressly prohibited or declared void by law. Meaning of void contracts. Void contracts are those which, because of a certain defect, generally produce no effect at all. They are considered as inexistent from its inception or from the very beginning. The expression void contract is therefore a contradiction in terms. However, the expression is often loosely used to refer to an agreement tainted with illegality. 2. Meaning of inexistent contracts. On the other hand, inexistent contracts refer to an agreements which lack one or some or all of the elements, or do not comply with the formalities which are essential for the existence of contract. Characteristic of a void or inexistent contract, there are as follows. 1. Generally, it produces no effect whatsoever, being void or inexistent from the beginning. 2. It cannot be cured or validated either by time or ratification. 3. The right to set up the defense of illegality, inexistence, or absolute nullity cannot be waived. 4. The action or defense for the declaration of its illegality, inexistent, or absolute nullity does not prescribe. 5. The defense of illegality, inexistent, or absolute nullity is not available to the third person whose interests are not directly affected. 6. It cannot give rise to valid contract. And lastly, number 7, its invalidity can be questioned by anyone affected by it. Effects of a void or inexistent contract. A void contract produces no effect whatsoever against or in favor of anyone. It waives no rights and creates no obligation. Hence, the ratification may be in the nature of a new contract. A contract that is void for being illegal may produce legal effects, but a contract that is inexistent because if there is absolutely no consent, object, or cause cannot produce any effect whatsoever. Next, equity as ground to uphold void contract. Equity, which has been aptly described as a justice outside legality, is applied only in the absence of and never against statutory law or judicial rules of procedures, when applicable positive rules should be preempt and prevail over all abstract agreements based only on equity. Courts exercising equity jurisdiction are first and foremost courts of law bound by rules of law and have no arbitrary discretion to disregard them. Equitable reason will not control against any well-settled rule of law or public policy. While equity might tilt on the side of one party, the same cannot be enforced so as to overrule positive provisions of law in favor of another. Thus, equity cannot be validity to avoid contract. On the Article 1410, the action or defense for the declaration of the inexistence of a contract does not prescribe. Action or defense for declaration of inexistence of a contract. This action or defense should not be confused with an action for the annulment of violable contract. Number 1. Action or defense imprescriptible. If a contract is void, a party thereto can always bring a court to declare it void, or and a party against whom a void contract is sought to be enforced can always be raised the defense of nullity, despite the passage of time, the defect being permanent and incurable. The action of defense does not prescribe. It will settle that as between the parties to a contract, validity cannot be given to it by estoppel if it is prohibited by law, or it is against public policy. It is not within the competence of any citizen to barter away what public policy by law seeks to preserve. The rule in Article 140 has been applied even before the effectivity of the new civil code. Number 2, necessity of judicial declaration. Since a void contract has no effect at all, it is therefore unnecessary to bring an action to declare it void. It is well within the right of the party cancel and treat as a void contract. In fact, such as action cannot logically exist. However, an action to declare the non-existence of the contract can be maintained, and it the same action. The plaintiff may recover what he has given by virtue of the contract. It is better that a judicial declaration of nullity be secured, not only to give peace of mind to the parties but also to avoid the taking of the law in their own hands. Number 3, rule where contract not void but merely violable. Violable contracts can only annulled by a proper action in court. Article 1390, within 4 years from the time the cause of action accrues. Article 1391, in an action to enforce a violable contract, the defendant cannot attack invalidity by way of defense and then ask for its annulment, but he can do so in a counterclaim because it is the nature of complaint. On the Article 1411, when the nullity proceeds from the illegality of the cause or object of the contract and the act constitutes a criminal offense, both parties being a pari delicto, they should have no action against each other, and both shall prosecuted. Moreover, the provision of the penal code relative to the disposal of effects of instruments of a crime shall be applicable to the things or the price of the contract. This rule shall be applicable when only one of the parties is guilty, but the innocent one may claim what he has given, and shall not be bound to comply with his promise. Next, rule on pari delicto. Generally, parties to avoid agreement cannot expect the aid of the law. The courts leave them as they are, because they are deemed in pari delicto or in an equal fault. Pari delicto is a universal doctrine which holds that no action arises in equity or at all from an illegal contract. No suit can be maintained for its specific performance, or to recover the property agreed to be sold or delivered, or money agreed to be paid, or damages for its violation. And where the parties are in pari delicto, no affirmative relief of any kind will be given to one against the other. Indeed, one who seeks equity and justice must come to court with clear hands. This rule, however, subject to exception. Article 1411 and 1419 that permit the return of that which may have been given under a void contract. Rules where contract illegal and the act constitutes a criminal offense. Under the Article 1411, it must be shown that the nullity of the contract proceeds from illegal cause or object, and the act of executing said contract constitutes a criminal offense. 1. Where both parties are in pari delicto, the following are the effects of contract whose cause or object constitutes a criminal offense, and both parties are equal guilty in pari delicto. 3A is the parties shall have no action against each other or as stated in the legal maxim. In pari delicto melior es conditio defendentes. B. Both shall be prosecuted. And the letter C. The things or the price of the contract as the effects or instrument of a crime shall be confiscated in favor of the government. On the Article 1412, if the act in which the unlawful or forbidden cause consists does not constitute a criminal offense, the following rules shall be observed. Number 1. When the fault is on the part of the both contracting parties, neither may recover what he gives by virtue of the contract or demand the performance for the other's undertaking. Number 2. When only one of the contracting parties is fault, he cannot recover what he has given by reason of the contract or ask for a full payment of has been promised. The other who is not at fault may demand a return of what he has given without any obligation to comply with his promise. Next are the rules where contract unlawful or forbidden but act not criminal offense. Number 1, where both parties in pari delicto. If the cause of the contract is unlawful or forbidden, but there is no crime offense, the rules are follows. Letter A. Neither party may recover what he is given by virtue of the contract. Letter B. Neither party may demand the performance of the other's undertaking. No relief can be granted to their party. The law will leave them where they are. The principle of pari delicto is grounded on two premises. First, the court should not lend their good office to mediating disputes among wrongdoers. And second, that denying relief to an admitted wrongdoer is an effective means of deterring illegality. Next, in Article 1413, interest paid in excess of the interest allowed by the usury laws by recovered by the debtor with interest thereon from the date of the payment. Recover of a usurious interest, any rate of interest in excess of the maximum allowed under the usury law is usurious. See comments under Article 1175. And if paid, may be recovered together with the interest thereon from the date of the payment in a proper action from the same Article 1413. A stipulation for the payment of usurious interest is void. The person paying the usurious interest can recover in an independent civil action not only the interest in excess of that allowed by the usury laws, but the whole interest paid. Article 1414, when money is paid or property delivered for an illegal purpose, the contract may be repudiated by one of the parties before the purpose has been accomplished or before any damage has been caused to a third person. In such case, the courts may if the public interest will thus be subserved, allow the property repudiating the contract to recover the money or property. Recovery where contract for an illegal purpose. Article 1414 is one instance when the law allows recovery by one of the parties, even though both of them have acted contrary to law. The following are the requisites for the application for this article. Number 1, the contract is for illegal purposes. Number 2, the contract is repudiated before the purpose has been accomplished or before any damage has been caused to the third person. And lastly, the court consider the public interest will subserve by allowing recovery. On the Article 1415, whereon the parties to an illegal contract is incapable of giving consent, the courts may, if the interest of justice of demands, allow recovery of money or property delivered by the incapacitated person. Lastly, the recovery by an incapacitated person. This article is another exemption to the in the parent delector rule in Articles 1411, 1412. Recovery can be allowed if one of the parties is incapacitated and the interest of justice so demands. It is not necessary that the illegal purpose has not been accomplished or that no damage has been caused to the third person. That's all. Thank you, everyone.